I now recognize the gentleman from Virginia, Mr. Hurt.
Director Cordray, over here.
Yep, coming.
Thank you for appearing before our committee. I represent a rural district in Southside, Central Virginia. Over August, we had the opportunity to travel across the district and met with a lot of folks that live on Main Street and are served by our local Main Street financial institutions. We have heard a lot of concern as we travel across the district about the CFPB and the impact that it's having on these institutions' ability to deliver access to capital. But the question that I wanted to focus on today relates to the Truth in Lending RESPA integrated disclosure rules that are going into effect. And I'll recount for you one conversation that we had with one of those representatives from compliance officer with one of those institutions, and said that they were glad that there was an announced effort to try to streamline those complicated, complex rules that have to be undertaken when closing real estate transactions, but were also concerned about the end product and concerned about the process. So I guess I was wondering if you could talk a little bit about your analysis in terms of the actual costs to consumers. What are will the costs be ultimately? Will this result in a higher costs, and how much extra time will be required, or if you could just talk about that briefly.
Sure. And again, it was Congress's decision that these forms really needed to be streamlined. They've been out there for 40 years, 2 different statutes, 2 different agencies.
You all looked at the cost
and yeah,
directly?
Yes, although it was a mandatory rule. We didn't have discretion to say we're not going to do this. We had to do it. We did our best to try to mitigate costs and make it feasible for industry. We spent a fair amount of time over it. I mean, this statute was enacted in 2010, and this rule isn't taking effect until now, you know, almost 5 years later. At the same time, we've been working with the industry extensively to try to help them comply, trying to provide a lot of guidance, trying to provide webinars.
Are you able to talk specifically about the costs and the analysis that you all have done about the specific costs that will be passed on to consumers, or the time?
I'm not convinced that there are going to be any significant costs passed on to consumers. I mean, it really is a change of forms. There's a lot of angst around the transition, but they made a transition 5 years ago when HUD changed the forms. This probably happened too fast in light of that, but Congress mandated it all.
Okay.
But they did it then. They'll do it now. It'll be a better, cleaner process. Consumers will understand these forms better. That's what our testing has shown. The industry will be benefited because consumers will be both clearer and happier about what they're doing, less angst around the closing, less surprises, you know, unhappy surprise at closing table with a lot of source of dissatisfaction. I think it will be better, but it's a matter of getting through it, and that's what we're on the verge of doing.
And as you point out, the timeline has proven to be a burden to a lot of these institutions, especially the smaller ones that have a hard time. There are a lot of partners in these transactions, and trying to make sure everybody's on the same page is very important. So I guess my question to you is I understand that the CFPB has rejected the request by the industry to grant a grace period for the implementation of this for the next 6 months, let's say, till February. It's my understanding that's been rejected, but I guess my question for you is will the CFPB pledge not to bring enforcement actions against those institutions that are acting in good faith? Obviously, we don't want people abusing that grace period, but will you pledge that you all will do that?
No, it's wrong that we've rejected that. In fact, I saw just the other day an article that may or may not be legislation on this.
So my question,
the CFPB has granted most of what industry wanted. We have done that, and we have made it.
But you haven't offered a blanket grace period for those who are acting in good faith in terms of not bringing an enforcement action. I just would like to get you on the record saying that if that's your position.
What we've done, I think, is actually better for the industry. We have worked with the other agencies, and as I said, this is going to be in writing. I've said it verbally. I've made my commitment, but it's going to be in writing by all the agencies that during the early period, and this may be less or more than 6 months, we will be diagnostic and corrective, not punitive. That means we're not going to hammer people if they happen to get the form somewhat wrong. We know they're trying to get it right. We know there's no advantage to them in undermining consumers by changing the forms in some way. They're just trying to get it right.
Right.
And I believe that. And so that's the way we're going to handle it, and that's the way I've talked to the other agencies about it. They agree. I mean, you're a former prosecutor. I know you know law enforcement, and you have to sometimes be a little
time
nuanced about it. We're trying to do that.
Thank you, sir.
Time of the gentleman has expired.